Today, the committee is meeting to consider the report on the Division of Revenue Amendment Bill, which was presented by the minister during his midterm budget speech. So we are all welcome.
And introduce the team that's going to present. Mr. Matonze?
Yes, Chairperson. From the committee side, there's no apologies unless if people are still going to be sending me an apology during the course of the meeting. And then from the Lawyers for Human Rights, I'll request Tandeka Chauke. She's here in the meeting. She just joined us. If she can introduce a team who are going to be in the meeting. Thanks, Chair.
Let's start with the members. Members, can I check if there are any apologies that you may have been noted? Okay, there's no apology from members. Yes, you can proceed.
Thank you, Chair, and good morning, honorable members. My name is Tandeka Chauke. I am the Statelessness Project Head at Lawyers for Human Rights, and I am joined today by my colleague Lindo Kutlem Dabe, who is the head of our Johannesburg Refugee and Migrant Rights Program Clinic. Thank you, Chair.
Thank you very much. Mr. Matonze, are we having two presentations or one presentation?
No, it will be two presentations.
Okay, so one will be done by Ms. Chauke, and the other one?
I think it will be done by yeah, we're head of migrant rights.
Okay, now we'll deal with those presentations at once. They will present, and then we'll also get a second presentation. Then members will interact with those presentations. I think we can proceed, Ms. Chauke. Thank you very much.
Thank you. Through you, Chair, can I hand over to my colleague Lindo Kuhle, who will begin the presentation, and then I will end off with the presentation on statelessness.
No problem. Thank you. You can proceed in that manner.
Thank you very much. We really grateful for the opportunity. I'm going to do the first 15 minutes of the session, and then my colleague Thandeka Chauke will then take over the second beat of the session, which will then cover 30 minutes. But essentially, this is the order in which I would like to present our submissions. So the first part would essentially deal with the digitization of asylum seeker and refugee system, and the sort of impact of that on migrants, on refugee rights. And then the second beat will deal with the documentation of children and our observations around that. And then the third beat will then deal with the systematic or structural xenophobia. I know we might have to debate the lexicon, but that's how the organization decided to describe the conditions that are faced by our client communities at Home Affairs. And then the fourth segment will then deal with the immigration detention, and then the last bit will then would constitute our recommendations around the issues. Okay, so on the first segment, we essentially deal with the impact of digitization of asylum on asylum seekers and refugees. It's basically how the system is affected asylum seekers and refugees. So we've noted that since we introduced the online system, and LHR has engaged with the system, and we have identified several challenges with the online system. So newcomers who are coming into the country who have an intention to apply for the refugee status then have to interface with the system. So in other words, they have to apply through the online system, and these are the challenges that they face. So firstly, we see lack of access due to lack of internet access, which is an obvious thing, and I'm sure we would have suspected that, given that there's a general lack of internet access and language barrier, this was always going to be an issue. But what we have seen is also that with the online system, there are additional requirements that are now imposed for migrants who intend to apply for the asylum or refugee status. And one of those is that they need to bring valid documents, and that if they fail to bring these valid documents, they may very well not have their refugee claims process. But even after they've filed their claims online, they will have to wait for 2 months to get an interview, and this of course renders them vulnerable to detention, because they have no documents in the meantime, and they do not have any proof that they are legal in the country. And when they get the interview, there's usually a shortage of interpreters, and the asylum seekers have reported that they are advised to arrange their own interpreters in certain circumstances. And NGOs are also inundated with DHA responsibilities, where we, for instance, have to provide affidavits and ensure that people comply with the requirements. What we've also noted in terms of documentation of children is that there is this resistance from the department to process what we call derivative joinder. So in other words, where there is a person who is already in the asylum seeker system or a refugee in the country who now wants to join in their children. These children would not be joined despite applications sent to the department for this purpose. And so children who are often minors would then be without documents. So under this, we have a couple of questions which we want to pose through the committee to DHA. So we want to know what challenges is the DHA facing in documenting children of asylum seekers and refugee, and we also want to know what is the plan to ensure that these children are timelessly documented. And then on the third segment, we have noted that issues of structural xenophobia, because of lack of proper documentation, we see that there is now limited access to socioeconomic rights and also services, whether be it public or private services. So because people do not have proper documentation, they would not, their right to healthcare will be affected, and their right to education and social security will be affected. So even though we have tried to write letters to hospitals and to schools to indicate that despite lack of proper documentation, migrants and refugees still have a right to access those services, we see that there is a practice to request for these documents and to insist on having these documents even when migrants have already tried everything that they can to ensure that they have these documents. So other institutions still insist on them. But we also understand that this is not the fault of the refugees. So under that, we have two questions which we seek clarity around. And so those two questions are essentially as follows. So how often does the Department of Home Affairs update government departments on the current asylum seeker and refugee documents and the challenges that they face? And the second question is, how many requests for verification has the Department of Home Affairs received since introducing the online renewal system? And then on the fourth part is essentially the issue of detention and arrest of migrants. So we know that this is regulated more broadly by the Immigration Act, and it does allow for state organs which are established in terms of the Immigration Act to arrest and deport migrants who are declared to be illegal foreigners. So there are legal norms related to migrant detention and arrest contained in a number of legislation. And of course, I've already mentioned one, which is the Immigration Act, the Regulation Act, as well as the Refugees Act and the regulations that are associated to those. So we have noted that there is no public information reflecting the number of people arrested and detained for purposes of deportation. There's also no public record of and the number of people deported from South Africa. And there's also no public record for a number of people arrested and charged with contravening, for instance, Section 49 of the Immigration Act. So the question we have to the Department of Home Affairs is to please make this information to be available. And also we are concerned that over the past 3 years, this information has not been made available. And what we've also noted is that there are poor detention conditions at Lindela and other related detention center. And we have very little information around how the South African human rights, for instance, they used to have a practice where they would monitor detention centers and their conditions. It is very unclear for us whether this is still happening. And we want to also know, given that now the practice at these detention centers is for a 48-hour notice to be given to the center before visitation. So we want to know whether is there any legal basis for this 48-hour notice before consultation takes place, and whether the South African Human Rights Commission continues to monitor these detention centers. We've also noted that there is an increase in immigration violation being processed through the criminal justice system, despite the ruling in the High Court that these are essentially administrative issues for Home Affairs, and that they are not within the realm of the criminal justice system. So the question that we have there for DHA is what is the purpose of this extended detention, and how is it a justifiable limitation on the constitutional rights? For instance, Section 12 and Section 35 of the Constitution. So recent contributors to the increased arrest and detention are essentially as follows. So during COVID-19, newcomers were arrested and detained for purposes of detention due to the closure of the RRO and the online system not catering for newcomers. And during this period, we saw a lot of arrest and detention. So now asylum seekers and refugees are being arrested for producing the online, the COVID-19 watermark permit. So that permit for most of the time, whether you were interfacing with police or private institutions like the bank, they would say that permit was either fake or and that it needed further authentication. So all of this is indicative, is an indication that DHA does not timelessly and effectively circulate information to the security cluster and other institutions to indicate some of the challenges that the refugees are facing and how vulnerable they are to lack of proper documentation. And then the question that we have there is, what is the process of disseminating information to the security cluster and other institutions regarding new rules and practices, and and whether implementation is monitored in that regard, so that we can prevent abuse by the security cluster. And other contributors really relate to the failure to follow processes prescribed by the law, essentially Section 41 of the Immigration Act and the regulation, and the failure to adhere to the rules set out in legislation and case law. I've already mentioned that there are cases that have been decided by the court on the fact that issues of migrants are administrative issues and that they should not be within the criminal justice system. And in the case of Ruta makes that point very clearly. And so the question that we have there is how are the security clusters and immigration services trained on application of the law and rules, and whether this training is something that is regular. And then the next question is, how are abuses of power in the immigration detention system monitored and dealt with? And we've also noted issues where there are children who are being detained. There has been a slight increase in this regard, but however, we have observed that this is still the case, and so we wanted to know whether there is a process to ensure that children who are detained are able to be verified as children, and whether there can be a different approach to children. So the question there that we have for DHA is how many minors, those are people below the age of 18, who have been detained over the past 3 years, and what is the current process if minor is found to be in detention. And we recommend, for instance, in this last segment, 2 things, and essentially we would advise that the DHA Asylum Seeker Management Directorate must urgently resume stakeholders engagement meetings to enable information sharing and the discussion of around challenges that are facing have been a cause of the online system. And so that we can give them like the real on the ground experiences of our client communities, and to perhaps find a solution around some of these challenges. And then the second bit of the recommendation is that we need a documented plan to operationalize the revisal of the delinking of children, of dependents, sorry, as we anticipate sending applications to the email address of one of the officials. Is not a practical thing to do. And then the last bit is that we require regular and direct communication with refugee and asylum seekers about the services available at each of the RRO offices. Thank you very much, Chair.
No, thanks very much. You can proceed, Ms. Chauke.
Thank you, Chair. I would just like to share my screen. If someone can quickly confirm for me, if you can see it.
Yes, yeah, you can proceed.
Okay, perfect. Thank you, Chair. So my presentation will follow a similar format to that of my colleague, in that we will address 4 broad issues in sequence, as well as pose particular questions and recommendations to the committee, as well as to the Department of Home Affairs. We've just included a quick snapshot of the situation of statelessness in South Africa. Of course, we all know what the definition is, but what I do want to emphasize for the purposes of this presentation is, and particularly in the context of South Africa, is that the definition of a stateless person under the 1954 Convention includes 2 manifestations of statelessness: the law and the implementation of the law. In terms of statistics, we all know that there's currently no mechanism in South Africa to gather conclusive data on the number of people who are stateless, but there are indications of estimates that have been published by the UNHCR, such as a global number of 3.9 million. At the end of December, I think it was about 4.3 million, but estimates are suspected to be higher at about 10 million. Domestically, we have a figure of 10,000 stateless people in South Africa, and this figure includes unrecognized South Africans as well as migrants, in acknowledgement of the fact that statelessness does not only affect migrants or refugees, but in majority of situations, people are in fact stateless in their own country of birth without having ever crossed an international border. The first issue we would like to touch on is the issue of access to birth registration and some of the persisting barriers to universal birth registration that we continue to see through our legal clinics. The first of those is the documentation requirement, wherein the Birth and Death Registration Act and its regulations make it a requirement for parents to produce valid identity documentation. as well as valid legal or proof of legal residence in order to register their children. I've just referred here to the High Court judgment in Naki versus Director General of the Department of Home Affairs. This is a 2018 High Court judgment in which the court ruled that it is in fact unconstitutional to make a child's right to birth registration contingent on the parent's documentation status. And the court there has ruled that officials need to apply a broader interpretation and implementation of those provisions and only request for identity documentation where it is available. The second barrier that we continue to see is issues around discrimination of children who are born to unmarried parents. And here I refer to another judgment in the Constitutional Court of 2021, which has ruled that children who are born to unmarried parents have an equal right to birth registration as those born to married parents. And of course, this case dealt specifically with the issue of birth registration by unmarried fathers or single fathers, where the mother is unable to register the child or is unwilling to do so. Ever since this judgment, we have continued to receive queries around the implementation of the judgment and access to birth registration for these children. We have reported at least 30 plus children who are born to South African citizen fathers, documented South African citizen fathers, who are still being denied their right to birth registration. In terms of practice, what we have, the trends we have picked up around this is that some officers will turn away the fathers and their children on the basis that they cannot implement the judgment without directives from head office, or they claim to be unaware of this Constitutional Court judgment, or they simply refuse to issue the DNA referral letter, or refuse to accept DNA results, or refuse to assist if the mother is undocumented or a migrant. So we're still seeing persisting issues around registration of children, where their fathers should be entitled and empowered to register them. And then just touching on the DNA issue, since that flows from that, we do still take issue with the fact that the DNA testing requirement is arbitrary, discriminatory, and exclusionary. This testing requirement has been implemented in terms of a 2014 circular that requires proof of paternity in the form of DNA test results if one parent is a non-South African citizen and where the Department of Home Affairs official has reasonable suspicion regarding the paternity of the child. Now, there has been mixed messaging since the Constitutional Court judgment as to whether or not the department would scrape this requirement, given that it is in fact ultra vires the law. It's not provided for anywhere in the Constitution or in the Birth and Death Registration Act. It is simply provided for in subordinate legislation in the form of this circular. In addition to that, it is discriminatory in the essence or in the sense that children who are born to poor or indigent families are then excluded from their right to birth registration simply because they cannot afford the DNA testing fees. So this is simply something that needs to be addressed and needs to be looked at, particularly with regards to vulnerable and marginalized children that fall within this category. The fourth issue is issues around backlogs and unreasonable delay in processing late registration of birth applications. So we are also seeing delays in panel interviews where we are working with social workers who are attempting to register the births of abandoned and orphan children and have been waiting for interviews for as long as 2 years or a couple of months, or have been waiting for the actual birth certificate after the interview has occurred. And then we're also receiving a few cases where applications are rejected without reasons. Now, in terms of questions that we wish to address to the Department of Home Affairs, as well as calling on the accountability role of the portfolio committee, is around implementation of court judgments. We want to understand when the Department of Home Affairs will implement the 2018 judgment in Naki, as well as the 2021 judgment in Center for Child Law versus Minister of Home Affairs, or what challenges the department is having in terms of implementing those judgments. We'd also like to know what are the mechanisms available for people who have complaints in relation to delays in terms of processing late registration of birth applications. Just to give an idea of the kind of cases that we see in our statelessness clinic In fact, a majority of our cases are related to issues of birth registration. Currently, we have 451 LHR clients, and this is about out of 800 clients. In the past 5 years, we've dealt with at least 1,213 clients facing barriers with access to birth registration. And the slide simply gives an idea of the demographics and country of origin information. You would have noted that those majority of the cases are in fact from children with links to South Africa, or those who are indeed South African citizens, but cannot access their citizenship due to these barriers in accessing birth registration. And then one issue that we did want to bring up, because this came up in the previous briefing that Lawyers for Human Rights could not attend, is the issue of the birth record versus the birth certificate in relation to a child's right to birth registration. In that meeting, the Department of Home Affairs made a presentation indicating that there had been a meeting between the minister and the UNHCR, wherein it was confirmed that the practice of South Africa issuing a record of birth children born on South African soil, but of non-South African parents is correct. The record of birth should be presented to the embassy of the parent's country of origin, and it is their responsibility to issue a birth certificate. Now, as Lawyers for Human Rights or civil society, we do accept that South Africa is not a jus soli state, and that citizenship is not automatic by reason of birth in the territory of South Africa. What we do try to emphasize is that the right to birth registration for every child born in South Africa is in fact guaranteed in the Constitution. It is a human right and a constitutional right and a fundamental child's right. Not only is it guaranteed in the Constitution, but it is also an obligation in terms of the treaties, the international and regional treaties that South Africa is a party to, including the Convention on the Rights of the Child and the African Charter on the Rights and Welfare of the Child. So what we are requesting here is clarity on this issue of birth record versus birth certificate. Is it simply a matter of terminology? Because we have seen it being referred to before as a record of birth, and then in the 2018 proposed amendments to the Birth and Deaths Registration Act, the confirmation of birth. Is this record of birth, the confirmation of birth, equivalent to a birth certificate? If it is not, then we need to consider the implications of having this document as opposed to a birth certificate, and the limitations that particular categories of children will face in following this process envisioned by the Department of Home Affairs, which is that the record of birth should be presented to the embassy of the parent's country of origin, and then the child will be issued a birth certificate. Because what then happens when we have children of refugees and asylum seekers who cannot register their children at the embassy or consular, and without a birth certificate, cannot then access family joinder or family unification at a refugee reception office? What then happens to those children who are born to countries of origin without consular services in South Africa, or where the consulates charge a fee for birth registration that is unaffordable to, for example, orphaned or abandoned children, or where the consulate requires the child to travel to the country of origin in order to obtain their documentation. And I think one other important thing to note is that stateless children are not recognized by any consulates. So what would happen in the case of that category of children? In terms of the Birth and Deaths Registration Act, it currently provides that children born to South African citizens are issued a DHA-5, which is the birth certificate with an ID number. And this is the point at which the children are entered into the National Population Register. And children of non-South African citizens are issued the DHA-19, which is commonly referred to as the handwritten birth certificate. So I think it's important for us to get clarity whether this birth record is in fact the DHA-19, which is the handwritten birth certificate. And then to also understand the implications of using the terminology of record of birth or confirmation of birth versus birth certificate. So the emphasis here is not on jus soli citizenship, but it is on universal birth registration for all children born in South Africa, as guaranteed in the Constitution and in our international laws. On access to citizenship, we do have Section 2.2 of the Citizenship Act, which is a very progressive provision that would provide protection for children born in South Africa who would otherwise be stateless, and Section 4.3 of the Citizenship Act that provides for citizenship and naturalization for children born in South Africa to other categories of migrants. With both of these sections, what we are still encountering is challenges in terms of implementation because of a lack of regulations. And the court in DGRR versus the Minister of Home Affairs in 2014, as well as the court in the Minister of Home Affairs versus Miriam Ali in 2020, have both ruled that the Department of Home Affairs is to publish regulations to support or prescribe the administrative process for such applications. Now, it has been 2 years since the department first published their draft regulations in 2020, and through the public participation process, civil society was able to submit comments, but there has been no clarity as to the status of finalization of these regulations. And while we do acknowledge the department's efforts in resuming citizenship services and beginning to accept these applications since February 2022, we're still encountering problems regarding the lack of clarity on procedure. So for example, we don't know how long it takes for someone to get a decision in terms of their application. And we are now starting to see some sort of inconsistency in terms of interpretation of some of these legislative requirements. So a question to the Department of Home Affairs would be, what is the status of the regulations, both in terms of Section 2.2 and Section 4.3 of the Citizenship Act? Here we've given an indication in terms of delay that NHR has submitted at least 57 applications between February and July 2022 and only received 3 decisions. And of course, the consequences are grave for the applicants in that these are young people who need their documentation to be finalized within a reasonable time in order to move on with their lives, to register for university, to apply for job opportunities, to apply for travel documents. So the issue of time is very important. We have also highlighted, I won't go into this into depth, but we also have persisting issues around durable documentation, solutions for unaccompanied and separated migrant children, which is a particularly vulnerable category of children. And here we've highlighted the limitations in terms of the Citizenship Act, the Refugees Act, and the Immigration Act in terms of accessing documentation for these children, and suggestions around the establishment of a special dispensation for this particular category of children. Lastly, the 4th issue we have raised is the issue around arbitrary deprivation of nationality or citizenship stripping through the Department of Home Affairs ID blocking or marking practice. And just to highlight that this is an issue that has been brought before or raised before the committee in March 2021, when Lawyers for Human Rights had the privilege of briefing the committee once again. And just to note that Lawyers for Human Rights is indeed still inundated with queries around blocked IDs. Around the issue of blocking or marking IDs, we would like to pose to the Department of Home Affairs a question or a suggestion around some sort of mechanism so that people get assistance directly from the Department of Home Affairs, as we see this more as an administrative issue rather than it should be a legal issue. So simply, we have upwards of 100 cases currently. You will see our figures in the past 5 years, at least 584 clients, and simply in most of those cases, people are simply trying to get assistance from the local officers and being taken from pillar to post with no clarity as to how they can resolve the block or mark on their IDs, what documents they need to bring, no notice procedure, no information about the nature of the investigation around them, no opportunity to make representations, and again, no clarity around issues of appeal or review in the case of ID blocking. Once again, we submitted some demographic data and country of origin information, and you would have noted from this once again that the clients that are affected the most are in fact those who are South African or in fact held South African documentation before. In terms of recommendations, we have made very broad recommendations around universal birth registration for all children, addressing the barriers we have raised, A second recommendation around providing durable pathways to documentation for unaccompanied and separated migrant children, but also including the establishment and implementation of child-friendly processes at all DHA offices, including in the civic registration system and the asylum processes at refugee reception offices. And the third recommendation is around alignment of all laws, policies, and practice to constitutional and administrative legal requirements. And the fourth is implementation of court judgments. We need to ensure that there is effective communication to all DHA officers on new court judgments and clear directives on implementation. And that brings me to the end of my presentation. Thank you, Chair. Over to you.
No, thanks very much for the detailed presentations on the work that, on your observation, as you have indicated in your opening. We are going to interact with this presentation, and I think there are some of the issues which you have already made your comment for department to deal with in terms of questions and also in terms of the recommendation. You will also be aware that we just received the Human Rights Commission report in our last committee meeting, that some of the issues that we're highlighting, they've made their observation. So it will be important that your presentation also, the interface on that front, so that we're able to have clarity on some of the issues that may not have been well covered by your institution. Members who are in attendance, Honorable Pillay, Honorable Molekwa, Honorable Tito, Honorable Kanyile, Honorable Makhale, Honorable Rose, Honorable Lizel, Honorable Lekhwase, and Honorable Mutise will then interact with the report and all the presentation, and will also bring again our colleagues to comment on the issues that we might have raised, and then we'll have a formula of how we're going to recommend or take your recommendation into summary, so that we assist each other with the observation that has been made. And I'm sure the department will not be far from the issues that you are raising. In that order, Honorable Pillay.
Thank you very much. Good morning, Chairperson. Good morning to all colleagues and members. And thank you very much to both presenters for the presentation that we received this morning. Chair, I think firstly, I want to recommend that we note the report and that specifics in respect of recommendations and discussions can be then held further with the Department of Home Affairs and see how we are then able to find ourselves, particularly in some of the issues that have been raised. But I think just as an observation, Chair, it's important to note that while there is an online system, there is a hybrid system. So there is walk-ins that are allowed and refugee centers have been opened. So I think that caters for, you know, the very first comments raised in respect of digitalization and the online system. But one of the things that's glaring is the recommendation on stakeholder engagement. And I think that as a department, this is ongoing and it is with relevant structures that are in place around refugees. And I think there must be a space that they find within the current processes and structures that we can be able to allow for that engagement. But I also want to say that in respect of registrations of children and having to have documents, that even with LRBs, there is a process, and we must be clear that there is even the request for DNA testing in respect of LRBs of South Africans who may not have been documented. And I think that it's a process that is not discriminatory, but one to be able to establish the true identity of an individual. But Chair, I think it's important for the committee to note, and we'll be able to deliberate further once we have been able to discuss with the Home Affairs Department. Thank you.
Thank you, Honorable Pillay, for your contributions. Honorable Molekwa.
Thank you very much, Chairperson. Let me also appreciate the presentation has been presented, Chairperson. We also want to know the challenges faced by the country with regard to the issue of illegal migrant, and which also affect the children born in the SA. We also know the backlog encountered by the panel of interview in the processing the applications to them. Chairperson, I just want to encourage the panel of interview to deal with the backlog and have a time frame in the investigation of the legitimacy and the confirmation of the child's parents' legality, or the investigation whether the child is an orphan or the parent were not married, and so forth, so that the process of the approval can take place, because the children cannot suffer because of the parents' sins. So I just want to check the involvement of the department in making sure that all those challenges that are presented in the presentation are attended to, Chairperson. And is there any program and the time frame to deal with those issues? Thank you very much, Chairperson.
Okay. Thank you, Honorable Molekwa. Honorable Tito. Okay, Honorable Kanyile.
Thank you, Chairperson, and good morning to everyone. I'd like to take this opportunity and appreciate and welcome both presentations that are before us. Chairperson, on the first comment that I had on the issue of the DNA, I believe that I have been covered by Honorable Pillay, but also wish to reiterate that I've also had a number of people that I was assisting to register their kids. And in most instances where a father is making an application for their child outside the 30-day period, their father, even if they're South African, they're required to submit the DNA results confirming the paternity of the child. Chairperson, I also believe that there are some of the questions that will need to be answered by the department. I believe you will guide us on how we are going to attend to them. There's an issue on the implementation of the court order or court judgment that was made in 2018 and in 2021. I believe the Department of Home Affairs will be in a better position to respond to that. And the issue of the blocked IDs, I will also appreciate if we can find time and have the department so that they can be able to come and assist us. I have had a case in Mpumalanga. I think there's a group of more than 3,000 people whose IDs were blocked. They went to court and got a court order that the Department of Home Affairs was supposed to unblock their IDs. I approached the department, gave them the court order. I was told on what steps they're going to take to attend to the matter. And 3 years later, nothing has been done. And a lot of those people, they've lost their jobs. Others are saying they're having guns, and now it means their guns are no longer licensed because now they do not have IDs. So we will appreciate if we can have the department coming on board to answer these questions. And another question that I'm also having, Chairperson, I once saw online there was a judgment indicating that if a child is born in South Africa, irrespective of the parents' particulars, that child must be given a South African birth certificate. But when I speak to the department, when I have some queries from the members of the community, I'm giving a different explanation. So I do believe that having the department before us will also help to guide us or to give us clarity there so that we can be better informed when we deal with members of the public. And lastly, Chairperson, I'm not sure if this question falls within our department or I need to take it to another department. What I have noticed, we have a lot of children that are born to people that are not of South African citizens. And most of these kids, they are being used at the traffic lights when parents are asking for donations or looking for extra cash. I would like to know that where do we stand as a country in terms of protecting the rights of those children, in ensuring that during school hours, they are also in school? But I guess you will guide us if this question falls within this portfolio or it will need to be taken up with other portfolios. Thank you very much.
Thank you very much, Honorable Kanyile, for your contributions. Honorable Mohale.
Thank you very much, Chair. Mine perhaps is just a question. The issue of the DNA test, because I feel it's very unfair, especially in terms of how it impacts on those who cannot afford. What then is the best way in dealing with this particular issue to ensure that at least people don't have to pay a lot of money just for them to be able to register their children? So I think maybe if we can get clarity from the department in this regard, in terms of what is the best way of dealing with this particular issue, Chair. Thank you.
Thank you, Honorable Mohale, for your contributions. Honorable Roos.
Thank you, Chair, and thank you to the for the very valuable presentation. I just want to start with the compliance with court orders and judgments, because it seems to be quite a big challenge with Home Affairs, and I think it's something that we certainly need to consider as a committee, to somehow get a list of these court orders and judgments that are going against Home Affairs that are not being implemented, because we've seen what's happening in the media with other permits, etc. But there's a lot of court cases here, which I think they're brought to our attention in these presentations. And we really, as a committee, if Home Affairs hasn't looked at that, we need to understand what is their process to process these court orders. How do they manage the adherence to them, etc.? Because I think we're seeing in the media that they're not really doing that, and that there doesn't seem to be a process. So I think that's something as a committee that we need to work on. Then for the LHR, you say that there's 10,000 stateless children in South Africa, or let's say stateless, and this includes unrecognized South Africans. What is the source for this number? And you also mentioned a figure of 15 million without legal identity. So also, what is the source of this figure? How do you work that out? Because if you look at the Pakamisa case, the respondents, which was the Department of Education, they indicated at that stage that there were 1.19 million undocumented learners just in school, of which 830,000 were South Africans and 167,000 were of foreign origin. So it's really a massive problem. But I think, again, we have a situation here where it's hard to tell what the size of the problem is there. So I'd just like to get a clarification of, where do you get those numbers from? Then in terms of the delinking, so my understanding is the delinking of migrants' dependents from their parents or guardians was initially done to prevent children being stateless and dependent on their parents' applications. So why is it now being pushed for it to be reversed? And then the refugee appeals, yes, it's criminally slow. But I think one of the complaints that Home Affairs always has is that many of the refugees and asylum seekers, or let's say asylum seekers, they don't answer their phones when they're contacted, so the number changes, etc. How in your experience of these things, how can that be resolved? Because if it is true and Home Affairs cannot get hold of them, how do they then process the applications going forward? Coming towards the end, Chair, I think we've looked at this child-friendly processes. I think it's an excellent recommendation. And it's something that we made a recommendation on in our BRRR, which will be debated today, where we looked at the mobile units. We looked at the need for, if there are children that are identified, particularly undocumented South African children are found at a school, that they are linked to a Home Affairs office, and that there's some sort of interaction with a social worker as well to ensure that that case doesn't drop when the mobile unit leaves. But one of those recommendations as well was a DNA test for indigents. And so I just wanted to mention that as well to the Lawyers for Human Rights, that is being followed up. But I think as well as a committee, that's something that we need to follow up. I mean, I have a case now where there's South African persons in Tshwane, for example, and we eventually had to assist them to get a DNA test. So at 30 years old, now they are going to become, they're finally going to get their citizenship. But one of them actually missed school because when you have to register with an ID number. And so they didn't attend school from grade 8 onwards. So I think this thing of the DNA test for indigents in particular, if you can prove that, it's critical because these people were sitting for decades, not able to get the citizenship simply because they couldn't afford the 1,750 Rand. So Chair, I think, we made very good recommendations in the BRRR, and it's something that we also as a committee need to follow up very diligently. Thank you, Chair.
Thank you, Honorable Roos, for your contribution. Honorable Khwase.
Chair, and let me also the presentations and note that Chair, one has an interest on hearing the responses from the department, as a lot of have been asked from the presentation, and one is expecting to maybe hear the side of the story of the department, especially that Ms. Chauke also raised and Honorable Roos and Ms. Nile have raised on the non-implementation of the outcomes. I would like to ask from Ms. Chauke, how does she deal, because she's saying she is receiving queries. I want to know how is she dealing or handling the queries, or is there a way that they used to resolve these issues with the Department of Home Affairs? I'm asking this question, Chair, looking at the possibility, because I take LHR as one of the stakeholders. I want to check in relationship between themselves and the Department of Home Affairs. And Chair, one, honestly, where I'm sitting, it would have been more interesting to have the department responding to some of the issues that have raised, because one is sitting here asking some similar questions to themselves, but I think the questions would be relevant being asked to the department. I think, like Honorable Pillay have mentioned, it would be important that we listen to the presentation or we have a conversation with the department on issues that have been raised, and we'll come back to have a full discussion on the issues that have been raised by us. Thank you very much.
Thank you, Honorable Khwase, for your contribution. Honorable Lizelle.
Thank you very much, Chairperson. Good morning to you and good morning to all the colleagues. I have been covered largely by all the questions that have been asked, but in particular, I was also interested to know, as the Honorable Roos had asked, to get more information about the 15 million stateless persons that was mentioned. But I think I also want to ask the presenters a question about the issue around the birth certificate versus the record of birth. I've heard what was said, but I want to know whether we've got perhaps international best practice in this regard. So in other words, if babies are born to illegal migrants in the US, the UK, Nigeria, India, etc., are they given legal documents or are they given a record of birth, something similar to which that Home Affairs is currently issuing in this regard? So I want to know, are we asking too much from the Department of Home Affairs, or are we asking them to comply with what is done in other countries? So do we have international best practice in this regard? Yes, I also wanted to ask about, if we could be given some insights into how one would reach asylum seekers if they do not or if they're not contactable. Honorable Ruiz also raised that. I also wanted to ask what is to be done to avert the risk that providing documents too easily will result in children being abandoned in South Africa. And it might seem like an unfair question, but when we had the public hearings on the Children's Amendment Bill, it was quite shocking to learn that in most communities that we went for these public hearings, many South Africans spoke about children that were abandoned in their communities, children born to illegal migrants. So it seems to be a reality. I do agree with all my colleagues that, I also serve on the Portfolio Committee of Social Development. And it is true that paternity tests, we also dealt with it in the Children's Amendment Bill. Paternity tests are done also for South African fathers. So it's not discriminatory or meant to be discriminatory, but I think it's something, of course, that, it's something that prevents children from being vulnerable to trafficking. So are the other mentioned proofs of paternity that was mentioned, is it reliable enough or more reliable in their view to prevent child trafficking and smuggling? And then I wanted to ask a question, what would be the reason for the high number? Of course, they're pointing to struggles or challenges that they've got with the Department of Home Affairs, and therefore we do need to hear from them. But I was looking at some of those slides where, with some of the citizens or people in South Africa, that have not received their documents, whether it's that they've applied for asylum or refugee status, or just generally people who are stateless. And if you look at some of those countries, I thought that international law dictates then that when you do apply for asylum or refugee status, that you should do it in the next country that is safe. And many of the people listed there are from the DRC, Nigeria, Burundi, and others. So I really wanted to know, it seems that people cross many countries to come to South Africa to acquire statuses and documents here. And I wanted to know, why is that the case? Thank you very much, Chair.
Thank you for your contributions, Honorable Lizelle. Honorable Modise Mza. Okay, can I check if Honorable Tito, she's now settled with the network? Honorable Mr. Matonzi?
Yes, Chairperson, both of them are there in the meeting. I don't know if maybe...
No, thanks, members. We appreciating the presentation that has been made before the committee, the observation on the work that Home Affairs is discharging, and the issues that arising from the presentation in terms of questions directed to the Department of Home Affairs and recommendations to that effect. And this meeting was primarily to receive this brief presentation from our colleagues. Will then compile a report that will be referred to the Home Affairs for them to prepare to deal with some of the issues that are arising. And I think, as you recall, that there are some of the issues which are affirmed as a positive work done by the department on that front, in line with what they're presenting here by the Human Rights Commission. So we'll do that exercise, and we'll schedule department to come and deliberate with the committee on the issues that you have raised. We'll then request yourself to comment, not to respond, to comment on some of the issues that are being raised, and particularly that they've been directed to yourselves, and members have raised issues that may be referred to the committee. There are two issues which I will request also, as you comment, you may need to highlight, or we can deposit that to the Home Affairs. Just as they established from the inset of your institution, or whether the relationship of work with Home Affairs and the issues that you have been raising with them over the period in your existence. Have you identified progress to some of the issues that you have been interfacing with them, or not? And what may have been the obstacles that you may have identified? I think it would be important that we can't always at particular time meet with yourself, and the issues that you have been raising with them are not being attended to or responded to in terms of the policy position of government and within the constitution framework of the Republic. So we may need to attempt to get a sense as to whether there is what is the attitude between yourselves as a stakeholder and the department in terms of the working relationship. We also know that we have signed, or part of the signatories with the international bodies around this subject matter. And you are fully aware that there was a delegation to Geneva to deal with some of the issues that are arising from the report. So some of the issues will take them with the department when they come and respond to the committee. I'm going to invite you, Mr. Ndabe and Ms. Chauke. I don't know who's going to start, just to give comment, response, and then we'll then assist to formulate way forward. Thank you, Mr. Ndabe.
Yeah, thank you very much, Chair. We have had conversations with the Department of Home Affairs, and given that we have different clinics in different provinces, these conversations are taking place through the clinic heads and the of course relevant Home Affairs offices in those provinces. But essentially, we have been addressing these issues at a very micro level, and we have been, of course, interfacing to address some of these challenges. We've had successful interventions in certain instances, but some of these interventions that we mention here are structural, systematic, and perhaps not suitable for the offices that we interface with at the local levels. So it might require a much broader intervention or political functionary who is able to address some of them, like a Director General or the Minister. So we may require assistance in that regard. And another issue which I think is important for us is the issue of paternity. So for paternity, our submission there is not so much that there is discrimination. The issue there, the gravamen of our complaint, I suppose, in relation to that issue, is in relation to affordability and cost, and particularly this applies to indigent parents. And the question there, I suppose, is who should be responsible for the cost. I'm aware that introduces a different character to the problem, but that is essentially the challenge, and that is essentially how we experience the challenge from our client community. There was also a question by Mr. Roos in relation to the delinking challenge. What we've noticed in terms of the delinking challenge is essentially attached to the question that the idea behind someone, behind a dependent applying for or applying to be joined to the main person who is the refugee status holder or an asylum seeker, who's in most cases an adult, is that you as a child or as a dependent, you rely on their claim. So your story becomes their story becomes your story. So and the basis of that claim is the claim itself becomes the basis for which they granted the refugee status. So you can't separate the two. So what normally happens is that if you separate someone who used to be a dependent because they've come of age, what you've essentially achieved is that you have stripped them of the claim, you've stripped them of the basis of the claim, and therefore they are left with no claim but to rehash their parents' claim. And so it's preferable to keep them in one file and to perhaps look at delinking in such a way that it doesn't prejudice someone who has come of age or a dependent who no longer requires any social assistance of their parents or the person they're depending on. So I think that's the challenge insofar as those issues are concerned. Thank you, Chair.
Thank you, Mr. Mdabe. Ms. Chauke?
Thank you, Chair, and thank you, honorable members, for your questions. So I will start with the issue of the statistics as per the request to provide clarity. The reference to 15 million people is that of people without legal identity. So it is not necessarily people who are stateless, but people without legal identity. And that is a statistic drawn from the 2018 World Bank data set on numbers of people without legal identity. So that is it's a rough figure that was provided for South Africa. And it not only refers to migrant people, but simply people living in South Africa who do not have legal identity. So that would include South Africans and non-South Africans. That figure is used as an indication of the prevalence of statelessness because the issue is that we don't have conclusive data on the number of stateless people, but such figures do help us to see that there is at least a population or significant population of people who are at risk of statelessness due to not having legal identity. And then the figure of 10,000 people stateless in South Africa is a figure we have come across from the UNHCR provided in 2016. I must be honest that I don't know the complete source of that. But once again, we can't say that it is a conclusive number. It is something that was used as an estimation, but this is why we complement this information with our own data from our law clinics, because that is where we see the numbers. As per example, the numbers I've provided from LHR's law clinic on birth registration clients, on blocked ID clients, and then we also have numbers for our citizenship application clients. And I think it is an opportunity or a time for us to actually reflect on this issue of data collection. We do need quantitative and qualitative data in the long run to see how best to address this issue of statelessness in South Africa. And this might be a discussion for another day, but the UNHCR has published a few guidance documents on issues of collecting data on stateless people through, for example, the population status, or by conducting a national study on statelessness. And in this national study, the Department of Home Affairs would actually have a critical role to play, along with civil society organizations and national human rights institutions. And then on the issue of DNA testing, I think I will just bring back the issue of discrimination. I don't want us to let that go. And just to expand on where that issue comes from, it is to do with that phrase, reasonable suspicion, in the circular. And this is a phrase included in the circular that allows local officers to apply a sort of unfettered discretion in cases where they can request paternity. And now, from the lived realities of our clients, or from the testimonials of our clients, we hear that this is usually in a situation, as I mentioned, where the mother is a migrant, where the mother is undocumented, or where the father is just viewed with unjustified suspicion. So the issue of discrimination is still at play with the issue of DNA testing, as well as the issue of cost. And there was a question around mitigating the risk of trafficking or children being registered for unscrupulous purposes. This is an issue that was in fact dealt with in the
Ms. Chauke got cut. Are you still online? Mr. Matonzi?
Yes, she's still online. I think she's muted.
Muted, yes. Ms. Chauke, we lost you. I'm sure you're muted or something. If you can.
Apologies, Chair. Where should I pick up from? Trafficking?
Yes, correct.
Okay. So that issue was dealt with in the Constitutional Court judgment, and it was noted that alternative forms of proof of a biological link, such as proof of birth that is issued at a hospital, can serve the same purpose, as well as when the mother is available to at least provide some sort of supporting affidavit, or the family, and then mechanisms through the Children's Court, where the Children's Court can also provide confirmation of paternity. Those are all alternatives that can be considered, as opposed to DNA testing. And DNA testing should be something that is only applied as a last resort, and there needs to be consideration about indigent families who can't afford this, because it cannot be that a child is blocked from accessing their citizenship or documentation simply because they're born into a family that cannot afford that 750 Rand for DNA testing. On the issue of birth registration as it pertains to children born to irregular or undocumented migrants, yes, indeed, there are documents that do provide best practice at international and regional level. And one such document is a guidance document on best practice issued by the UNHCR that deals with birth registration for the prevention of statelessness. In relation to the documentary requirement, the suggestions there are for civil registration authorities to accept alternative forms of identity where the parents do not have identity documentation themselves. Some examples that are noted are in Lebanon, where the government actually accepts the Syrian family booklet as proof of parental identity and marital status to register births. In other African countries, the practice of accepting witness affidavits or testimonials from people who might have witnessed the birth of the child are also accepted as alternative forms of parental identity. In the regional system, the African Committee on the Rights and Welfare of the Child has also published a general comment dealing with birth registration, and again issued examples of best practice on how to navigate the issue of documentary requirement. But at the end of the day, the emphasis on all of this is the best interest of the child and how we ensure that children are not punished for the sins of their parents and not have to inherit the documentary issues of their parents. So we indeed have to find alternative ways around the documentary requirements. And even to note that even for South Africans who are born outside of South Africa, one of the foreign birth registration requirements is a birth certificate from your country of origin. So I would submit that it is not asking the Department of Home Affairs for too much when we say that they should issue birth certificates to every child born in South Africa, because without those birth certificates, those children will not be able to even claim citizenship in their countries of origin. And on issues of compliance with court orders and judgments, we do welcome the Portfolio Committee's suggestion for a list of court orders and judgments that can assist not only the Department of Home Affairs, but all of us with an interest in terms of advancing the rule of law and protecting human rights, to monitor implementation of court judgments and to ensure that people are in fact getting relief when they have had to go all the way through the court system. And that is also something that NHR can commit to providing the Portfolio Committee with a list of judgments that at least we have. In terms of queries and in terms of progress and obstacles, thank you for noting that, Chairperson. I think I also accept that comment that we do need to find a way forward and a way to work efficiently together. What we have been attempting to do in terms of addressing our queries is engaging with the Department of Home Affairs. But as Linda Kuhle mentioned, that sort of engagement is very difficult from the local office level. It has to be a top-down approach, but of course the availability of senior management is quite limited. And what we're also facing with lower level staff is non-response to some of the issues or queries that we raise. For the context of the statelessness project in particular, we do recommend that at least some sort of mechanism where we could engage with local office managers in a case management forum that meets periodically to discuss some of the complicated cases that we see might be a way for us to actually map a way forward and to find resolutions for the hundreds of clients that we see with problems. Dialogue and capacity building, I think, is also something very important. Just to put it on the table that civil society is always available for capacity building and dialogue with the Department of Home Affairs and particularly the local offices. When we cannot get relief, of course, our last resort is the court, whether it's the Children's Court or the High Court, but this is simply because our clients do need assistance at the end of the day, and we only then resort to litigation when we haven't managed to get any other form of relief on behalf of clients. I hope that addresses all the questions. Thank you once again, Chair.
Thanks very much, Mr. Mtabe and Ms. Chauke, for having presented to the committee, made your observation and interacted with members of the committee on the issues that you have raised, you have highlighted, and the questions that you have posed to the Department of Home Affairs. We must appreciate that you have identified some of the working relationship with the Home Affairs and where the obstacles we have to interact with the Home Affairs when they're going to respond. What you are going to do will then note this observation in the committee and refer the presentation to the Home Affairs with specific areas, in particular those that members have raised and the issues that you have raised in your presentation. We'll then schedule the department at an appropriate time, guided by our programming schedule, to interact with the department on this conversation that we have just held with yourself. And I think we'll also request the department also liaise with you in the period of this when we're interacting with them. At the time they are coming to the committee, at least there could have been some interaction with the team. We also appreciate that you have been interacting with all the offices where there were interventions made, and I think what is encouraging that when there are issues, some of the issues may not need as we're indicating, the higher executive, but the capacity in terms of the groundwork of the offices and our personnel may need to interface with that space. We affirm that the law of the country must always guiding our decision processing making. and interaction with our citizens, both who are seeking intervention from the country in terms of the documentation in the department, and also the citizen of the Republic. So we are firm on that in terms of the laws and the constitution and that have been established to guide this process of the immigration front. So we're going to do that, and I want to thank you for having interacted with the team, and also thanks members for considering to listen to these observations that the colleagues have presented and refer some of the issues in the Department of Home Affairs. Mr. Matonsi, we're going to end this session in that manner. I'm not sure if you have any other issue, Mr. Matonsi, to guide.
Chairperson, no, there are no other issues except that the issue of the queries, we are not going to be dealing with it as shown on the agenda in the beginning. I've spoken to the acting DDG. He would be sending me a spreadsheet by Friday. So once I get it, and then I'll send it all to all members of the committee.
Okay. Thanks, members. Thanks, Mr. Ndabe and Ms. Chauke for representing your team. And thanks, Mr. Matonsi and Mr. Salmon and all the colleagues present here in the team and officials who have been in attendance at this meeting. Our meeting stands adjourned.
Thank you, Chair.
Bye-bye.
Thank you, Chair.
Thank you.
Thanks, bye.
Thank you. Bye.
Thank you, Chair.
Thank you, Chairperson.
Thank you. Good luck, Co-Chair. What's going to happen today?
Nothing is going to happen. Everything is fine.
I see.
Bye, Jay.